All right, so for our second mini lesson, our flipped classroom mini lesson over the judicial branch, we're going to pick up here where we left off with criminal law. So, a few important points. A criminal case is introduced by the government, that is, the representative of the government. That representative of the government claims that a person or group has committed a crime. So the government's prosecuting attorney is going to seek to convince the judge or jury that the defendant, the person who's accused, has both committed a crime and wanted to commit the crime. You've all seen crime shows, movies, those sorts of things where you see this played out. In these cases, the defendant, of course, has a right to testify to defend himself or herself, but you also have a right not to incriminate yourself, and you don't have to testify. Lots of times in criminal trials, what you'll see is that lawyers and defendants, for multiple reasons or for various reasons, they choose not to testify. If a defendant is found guilty of breaking the law, he or she can be punished by being put in jail, or they can be made to pay a fine, and in some cases, they may be made to do both. So, there are two classes of crimes. Again, this is very important, so we're going to go over this slowly. Two classes of crimes under criminal law. There are crimes for which the punishment is less than a year in jail. These crimes are called misdemeanors. Again, crimes for which the punishment is less than a year in jail are called misdemeanors. Crimes with punishments of 1 year or more in jail are more serious, and these crimes are called felonies. Guilt is harder to prove in a criminal case. The bar is set high. The prosecutor in a criminal case must prove that the defendant is guilty beyond a reasonable doubt. That the defendant is guilty beyond a reasonable doubt. Again, two classes of crimes. One is less serious. You can receive less than a year in jail for it. It's called a misdemeanor. Crimes, however, with punishments of 1 year or more, they are more serious, and they are called felonies. So, unlike criminal law, there is another class, and this is called civil law. This does not involve violations of criminal law. A civil case is introduced by a private party. We refer to that private party as a plaintiff. This plaintiff is usually seeking monetary damages. So what the plaintiff does is they bring their complaint to the court's attention, and they try to convince a judge or a jury that their complaint has a real basis. So they bring this case to the judge's attention, and they plead their case. They're trying to get the judge to agree with them that they've been wronged in some way, and that they need to be compensated for it. The defendant may be forced to testify in a civil law case. The defendant in a criminal law case, remember, cannot be forced to testify. They may choose to, they may not. But in a civil law case, the defendant can be forced to testify. In a civil law case, the plaintiff proves guilt of the other party by a preponderance of evidence. Then the defendant may have to pay money to the plaintiff. Notice the difference. In this case, this class of law, civil law, it's only a preponderance of evidence, whereas in the criminal law class, the prosecuting attorney has to prove the defendant's guilt by beyond a reasonable doubt. That's beyond a reasonable doubt. Most civil cases are resolved out of court, and people found guilty in civil cases never ever have to go to jail in most cases. So let's go back there. If we look at this chart, we can see on the left criminal law, list the things, the conditions for something to be a criminal law. Injury to the public, it's prosecuted by the government, attorney provided if the defendant cannot afford one. The burden of proof is beyond a reasonable doubt. A conviction may result in civil disabilities or loss of liberty. Penalties potentially include loss of liberty. You can go to jail for violations of criminal law. On the other hand, you look at civil law on the right, and we have a private injury or wrong. It's not a crime that is committed against the state or another person that can get you charged with a criminal law offense. In this case, in civil law, the plaintiff sues the defendant. The parties must provide their own attorneys. In criminal law, if you can't afford an attorney, then if you're the defendant, then the state will appoint you one, and it's the government that is charged with prosecuting it. But in civil law, parties must provide their own attorneys. The burden of proof is a preponderance of the evidence, not beyond a reasonable doubt like it is in criminal law. No civil disabilities and no loss of liberty are part of the civil law case. Penalties are typically monetary. So let's talk about Georgia's jurisdictions. So what is jurisdiction? Jurisdiction is the power, the right, or the authority to interpret and apply the law. So Georgia's adult justice system consists of courts of 3 different types of jurisdiction. They're general, limited, and appellate. So what's the difference? General jurisdiction is Georgia's general jurisdiction trial court. It's the superior court. In this superior court, we have land disputes, felony cases, and divorce cases that are all handled by this court. Limited jurisdiction. The 3 limited jurisdiction courts are state trial courts, probate trial courts, and magistrate courts. This means they have less area that they have power in. State trial courts exercise limited jurisdiction over misdemeanor criminal cases, such as traffic violations, and civil cases. For instance, if you get a DUI, then the first court it goes to is the magistrate court or municipal court. And if you appeal or you don't want it there, then it gets kicked up to the state trial, and you can have a jury trial there. Probate trial courts, they exercise limited jurisdiction over marriages, like marriage license, wills, guardianships, and estates. These courts also supervise election ballot printing and vote counting. Then we have magistrate courts. They exercise limited jurisdiction over minor civil claims, like we talked about earlier, bad checks, arrest and search warrants, and ordinance violations. These courts do not have jury trials. And then we have the appellate jurisdiction. The 2 appellate jurisdiction courts in Georgia are the Court of Appeals and the Supreme Court. Neither one of these courts holds jury trials or hears new material, as all cases have been heard in lower courts. So they're not relitigating the case by the time they get to the appellate jurisdiction. They are not hearing new material. All of that stuff has already been heard in lower courts. The Court of Appeals has jurisdiction over appeals from the superior and state courts. In the adult justice system, it hears appeals for civil claims for child custody cases, damages, and criminal cases except felonies, while the Supreme Court has jurisdiction over appeals related to wills, divorces, and cases where a sentence of death was or may be given. So, what are the steps in the criminal justice process? We've talked about courts and judges and jurisdictions. So how does it actually work? Well, number 1 is arraignment. If you were arrested, a suspect has to have his first court appearance between 24 and 48 hours after an arrest. There's a judge, and the judge will review the circumstances involved and decide whether or not there's probable cause for the arrest. The suspect is read his or her rights under Georgia law. And during the arraignment, the suspect can have a lawyer. No evidence is presented at this point. It's just an arraignment to decide if there was a just cause for the arrest. Bail. Bail is set if the crime is nonviolent in nature or if the suspect is likely to run away. The suspect can go about his or her daily business until his court date. If the suspect is out on bail but does not return when scheduled, a warrant is issued for his arrest and he or she will be put in jail. If bail is not set or he is unable to pay the bail, the suspect is held in jail until the court date.